Good morning, everyone, and welcome. We're pleased to have all of you with us today. We have 3 cases on the morning docket, and we will call them in the order in which they appear. Let me remind council that each side has a total of 15 minutes, and that includes whether there's one or multiple appellants or appellees. The appellant does have the opportunity to reserve up to 5 minutes for rebuttal. So when your case is called and after you've introduced yourself, let us know how much time to reserve and we will program the clock accordingly. Are there any announcements? Hearing none, please call the first case.
Aureus Holdings, LLC, doing business as Media Brewery versus 3803 Partners, LLC.
Please come forward.
Good morning. I would like to reserve 5 minutes for rebuttal, please.
5 minutes, very good.
Good morning, Your Honors. Brad Scarborough here on behalf of the appellant, 3803 Partners, LLC. And may it please the court, this is an appeal that my client filed from the granting of 2 summary judgment motions, actually. And just to give Your Honors a little background, procedurally, this case began by Aureus as the tenant filing suit against my client, 3803, as the landlord. Aureus was seeking to recover approximately $4,100 in a security deposit and a tenant build-out deposit of $41,000 and some change, each of which would have been returned to the tenant at the expiration of the term had the tenant not been in default at such time. My client filed its answer, and in the answer we filed a counterclaim for breach of contract for failure to pay rent. At the time that the dispute arose and the termination occurred and the lawsuit was filed, there was still a couple years left on the lease term. So the case kind of continued out a while so that the lease term would run out, so we would know at the end of the term if we had damages, what those damages would be after we mitigated the damages by putting a substitute tenant in the space. So the pertinent dates that I want to run through real quick are that soon after leasing the premises, unbeknownst to my client, the tenant, Aureus had subleased the space to another company. And either Aureus initially occupied it or shortly thereafter subleased it to another company. But then in the summer of 2019, the subtenant and Aureus vacated the premises. But they still kept paying rent at that time, and they were working to try to find a subtenant for the space. And they were working with my client to try to find a subtenant for the space. And however, that did not pan out. But notably, it's interesting that once my client was able to release the space to the substitute tenant, they actually leased it for the same rent amount that Aureus was advertising to subtenants to rent the space. But in January of 2020, Aureus, the tenant, stopped paying rent. And shortly thereafter, I think it was January 9th of 2020, the representative of my client, Mr. Steve Francis, emailed Aureus and said, hey, what's going on? We haven't gotten your rent. And then the correspondence really heated up from there. So over the course of from early January until early March, there was a lot of correspondence back and forth by email, telephone calls, and whatnot as to, hey, when are you going to pay rent? Well, there were several promises, hey, the rent's going to come, we're working on trying to sell the business, things of that nature, but it just never happened. But in response to the counterclaim that my client filed for breach of contract, Aureus filed their reply, and they just conclusorily listed a few affirmative defenses. And they did not set forth facts to support those as required by Rule 803 of the Tennessee Rules of Civil Procedure. And in fact, my client eventually filed a motion for judgment on the pleadings, pointing out to the court, hey, they listed some affirmative defenses, waiver, the typical, hey, we rely on waiver, estoppel, unclean hands, whatnot, just list them out. And obviously that is not proper under the Tennessee Rules of Civil Procedure because you have to affirmatively set forth facts to support those. So we filed a motion for judgment on the pleadings asking that those affirmative defenses be ruled upon and disposed of. But as you all can tell from the record, the court denied that motion as moot when she ruled on the summary judgment motions. And in fact, it kind of makes sense that would have happened because in ruling on the summary judgment motions, the trial court did not rely upon any affirmative defenses. So I guess the court at that point said, well, the affirmative defenses are all moot because I've basically put down an order that disposes of the entire case, and the court didn't rely on the affirmative defenses.
Well, both parties moved for summary judgment, and the trial court denied both motions, at least in part. And with regard to your client, I believe it's paragraph or section 26 of the lease agreement that gives your client two alternative remedies if the tenant doesn't pay rent or defaults in some other way. And one is to give notice of default.
Right.
The trial court found that your client never gave notice of default. The court found that there was correspondence back and forth, but there was not a piece of paper or an email that constituted a notice of default.
Sure.
What communication do you rely upon that constitutes a Rule 26 notice of default?
Well, if I could take one step back from that, and the court actually granted both parties summary judgment motions
instead of
and
denied.
denied both parties summary judgment motions.
True.
So the court,
It gave neither party relief.
right, this was a first for me, Your Honor.
Yeah.
The court basically said both parties lose.
Well, you're going to stay where the court found you because neither one of you complied with the lease in the court's opinion.
Right.
But back to the Rule 26, Section 26.
Sure.
Notice, what document or communication do you rely upon that shows that your client complied with the lease?
All of the documents and communications,
So
all
all
the
of it.
communications, all the phone calls, because paragraph
So
26.
Did you ever invoke paragraph 26 to them?
Paragraph 26 did not require giving notice of a default. And we briefed that thoroughly in our papers. The court said that the court believed that you were required to give notice to the tenant that you considered them in default.
Counsel,
When you read
what does written notice of the same mean then? In section 26, you're required
Yes.
to provide written notice of the same.
Sure.
What does written notice of the same mean?
Well, and as paragraph 26 says, in the event that the lessor fails to pay the rent as herein stipulated, unless the lessee corrects or remedies any such failure within 30 days or such other time limitation as may be specifically provided for elsewhere in this lease, after lessor has mailed written notice of same to lessee. So what the paragraph says is, you've got to give them written notice that they haven't paid rent. You've got to let them know.
You've got to give them written notice that the landlord is declaring the lease in default. The tenant knows they haven't paid the rent.
Nowhere in this paragraph does it say that the landlord has to give notice that the landlord is declaring them to be in default. All it says is you have to give them notice that they.
Who else would make that declaration?
Well, a court would make the declaration as to whether the failure to
So
pay
you're
rent.
supposed to go to court and get the judge to issue a notice of default, and then the tenant has 30 days from that court order to cure the default.
Well, I think that's.
No, is that what you're saying?
No, that's
what I
I'm
heard you
saying.
say.
No.
You said you go to court and the court issues the notice.
You said who would declare them in default? And I said, well, a court would declare and adjudicate that a party was in default. Because
but the lease doesn't say that.
the lease
The
does
lease
not.
comes a whole lot closer to saying what we're indicating than what you're indicating.
Right. Nothing in the lease says anything about the landlord being required to declare a default. They don't have to say, the landlord.
What does Section 26 require?
It requires them to give notice that they have failed to pay rent. That's the plain language of paragraph 26 says that you have to give them notice that they failed to pay rent.
The trial court here seems to have viewed it as notice of which option you were exercising, right? And that seemed to be the chancellor's understanding here, is that you were to give notice that, because you could have allowed them to continue to stay and seek damages for unpaid amounts or whatever other harm, and you didn't provide notice until March that you were going to ask them, essentially, you were going to bring the lease to an end.
Sure, and we addressed that in the brief, and we hit it pretty good in the reply. Basically, the contract says, if you give this notice and you give them the 30 days, and here it is, 30 days notice that they failed to pay rent, then you can exercise all of these remedies, which a lot of those remedies are even remedies that are in addition to what the common law damages remedies would be. Nowhere in the lease does it say, as a condition precedent to you being able to recover damages, you have to satisfy this, this, and this. There's nowhere in the lease that says that, and we pointed that out to the court. We said, Your Honor, you have not given us a legal reason why you have dismissed our claim for damages. You in fact said, we showed and we proved breach of contract, but you haven't given us a legal reason why you're dismissing our claim. And that's what we went back with the motion to alter amend to say, what is the legal reason? It's not condition precedent. It's not a limitation on liability or any of those things. So we were just at a loss, as we still are, as to what the legal reason.
Did you draft this lease? Whose
No,
form is
this was a lease that was negotiated by the parties and revised between the tenant's attorney and my client prior to me ever becoming aware of this lease. So, but it was a mutually drafted lease.
All right, thank you. Your time is up, but we'll
Thank
hear
you, Your
from you
Honors.
on rebuttal. Good morning.
Good morning, Your Honors. My name is Keen Barger. I represent Aureus Holdings, LLC. I respectfully request that you affirm the trial court's dismissal of 3803's breach of contract counterclaim and reverse the trial court's dismissal of my client's breach of contract claim. I think the starting point here is that notice and cure provisions serve a very important purpose under Tennessee law. And that purpose is to give a party an opportunity to cure an alleged breach so that the parties can, if possible, avoid costly litigation. Unfortunately here, 3803 didn't follow Section 26. The lease includes a notice and cure provision. It gave options, as the court already discussed, prior to terminating the lease, re-renting, and seeking damages, which is what 3803 indisputably tried to do here.
But you did give them notice that they hadn't paid, and you did give them an opportunity to cure, right? So wasn't this notice sort of substantially met?
No, Your Honor, it was not, and for several reasons. I'll start with the fact that, one, there was no notice of default, just as a factual matter. You can review the emails. They say, we are okay with you not paying rent. The next one says, when are you going to pay rent? Even the March 5th communication, the day before the new tenant was moved into the premises, 3803 said, we are in agreement that you are going to pay rent today or tomorrow. So at no point was a notice of default declared. Second, Section 26 required a written notice of default via mail. It's undisputed that there was never any mail sent. So factually, there was no notice of default, but there was no mail. And at least below, 3803 attempted to argue that email satisfies the mail requirement. And I would just say that an ordinary person who is told that a document has been mailed to them would walk out to their mailbox, not run to the nearest computer. And in fact, Ballantyne's Law Dictionary defines mail as, quote, to place a letter or other mail matter properly enveloped or packaged, addressed, and stamped in a mail slot, mail chute, or mailbox provided by the Post Office Department for the reception of mail, and the Tennessee Rules of Procedure distinguish between email and mail. Tennessee Rule of Civil Procedure 5.02 discusses mail on the one hand and email and notice via electronic mail on the other hand. Third reason, Tennessee law is very clear that because of the important purpose of notice and cure provisions, which is to avoid costly litigation, that they must be construed strictly. So I've heard 3803 articulate some argument, I don't quite understand it, that all had to be said was just stating the fact of non-payment, as if that's enough. I've read Section 26 numerous times. Has a few long sentences, a lot of clauses that run together, but it's not at all clear to me that that's all 26 required. It's
Why
not
isn't that all that of same requires? And the language of same. The 26 begins with a reference to non-payment of rent. Why isn't of same notice of non-payment of rent?
For a few reasons. Section 26 first uses the word default on 3 separate occasions. In 3803's papers, they enjoyed quoting Section 26 and bolding and highlighting every portion of that provision that other than the word default. The word default has a very specific meaning in the law. It's a party exercising an option, a legal right that they have in order to declare a default. I would also point the court to Section 29 of the lease, which, as you know, all provisions in the lease need to be read harmoniously and in pari materia. It says, lessor shall have the right to declare any such default. So Section 29, read in pari materia with Section 26, clearly indicates that Section 26 requires what every contract in this arena requires, which is an actual notice of default.
And so I'm a little lost why there isn't rent payment due, at the very least in this case, for January, February, and March. And the chancellor seemed to look at this and essentially see it as, well, if you didn't provide the proper notice, then that past rent isn't due. And isn't rent still due here for January, February, and March under the general terms of the lease agreement?
No, it is not, Your Honor, and that's because of the doctrine of first uncured material breach. The case law is clear that when a party commits the first uncured material breach, that discharges the other party's obligations under the contract.
What and when was the first material breach, in your opinion?
Yeah, the first material breach occurred on March 6th, and that was when 3803's counsel sent the letter to Aureus declaring the lease terminated and declaring that they would then seek damages.
Why wasn't the failure to pay rent in January the first material breach?
No, because the case law is very clear that although I think lawyers, we like to use the term first material breach because it's a little shorter, sounds better. In fact, the full name of the doctrine is first uncured material breach. And the term uncured is really important. If there's in the construction context, for example, the common law imposes an obligation to give notice. In the contract context, the contract provisions can impose an obligation. And I'll just point the court to the case law that we cited in our brief on this point, if I can just find it. This is a quote from Carter v. Kruger, published Tennessee Court of Appeals decision. Even if a party, quote, may have been first to breach a contract, that party is not barred from recovering damages when the other party failed to give notice of claimed defects and failed to give the party an opportunity to cure the defects.
Well, there was certainly a notice in this case they hadn't paid rent, an opportunity to cure that failure to pay rent. That's
correct, Your Honor. There was the fact that rent had not been made was known to both sides. What was not known is that 3803 was exercising its option to terminate the lease under 26. That was not made clear until March 6th, which is after the new tenant had already been moved in, which that's a material breach, and before the 30-day period to cure had run. I think one thing we haven't spoken about yet is the argument that 3803 led with in its brief, And that's the argument that the trial court somehow did not comply with Rule 56.04 by not giving a reasoned decision that was capable of appellate review. I don't want to make too much of that argument other than to say the trial court entered a 13-page opinion. It was very clear, in fact, why she denied 3803's breach of contract claim. She could not have been more explicit. It was due to 3803's failure to comply with Section 26, and that was the correct result. The flip side of that coin is moving to my client's own claim for breach of contract, for which it seeks damages. The trial court denied my client's claim for breach of contract on the basis that my client was in default at the time of termination, which was on March 6th. And therefore, she denied my client's ability to recover the approximately $40,000 prepayment of rent and an additional $5,000 security deposit. As I've discussed before, the doctrine of first material breach means that 3803 was the first party to commit the first uncured material breach, and so Aureus is then entitled to damages. And I think it's helpful to look at sections 5 and 6 of the lease agreement, which govern the prepayment of rent and then the security deposit, respectively. So section 5, governing the prepayment of rent, expressly references section 26. So in other words, keeping the prepaid rent is among the remedies available to 3803 after it follows the requirements set forth in section 26. To put it, I guess, in simpler terms, a lawful termination of the lease is a precondition to 3803's right to keep the prepaid rent. Section 6 similarly expressly references, quote, termination of the lease. And how do we know that you terminate the lease? Well, we look at section 26. So both of these provisions point back to section 26 and the fact that 3803 had to lawfully terminate before it could keep the approximately $45,000 it had received from my client. And then in the few minutes I have left here, I'll briefly touch on the attorney's fees arguments at the end of the papers. So there's a few things to note there. First, 3803 has said that it's pursuing attorney's fees under section 31 of the lease. However, we're operating here under section 26, which contains its own attorney's fees provision. And given the fact that we're dealing with section 26, which is the more specific provision at issue here, that attorney's fees provision would govern. And as the trial court correctly held, the fact that 3803 failed to comply with section 26 means it is not entitled to any of the remedies in that provision. That includes attorney's fees. 3803 is not entitled to attorney's fees under section 26 because it failed to give notice of default and opportunity to cure as contractually required. Even if section 31 governed, which it did not, 3803 is not entitled to attorney's fees under that provision either. First of all, 3803 did not enforce the collection of rent, which is what was required under the first prong of section 31. And due to the failure to enforce rent, not entitled to attorney's fees.
How so? How have they not had to enforce the payment of rent? And your client didn't pay rent. They had to go to court. They're still in court trying to enforce the payment of rent.
Yes, I think the answer to that is in the White v. Empire case. It's a very similar case to the one here. The plaintiff brought a claim against the defendant under a lease, and the defendant actually successfully defended against that claim. It won, and it's counterclaimed for attorney's fees. And the defendant made the exact same argument here, which is we successfully defended our rights, therefore we have enforced the terms of the lease agreement. And the Tennessee Court of Appeals disagreed. The court said the word enforce means you're actually enforcing one of your rights, not defending your actions under the lease. And that's a binding decision here. It's indistinguishable from the present circumstances.
Would you make that point again? I didn't follow it.
Yeah, sure. So when you look at the second prong of Section 31, the language is, attorney's fees may be awarded to enforce compliance with any of the covenants or agreements contained herein. And in White v. Empire, a defendant in a lease case successfully defended itself in a breach of contract claim and sought attorney's fees. The Court of Appeals said, even though you successfully defended against the claim, under the plain terms of the lease, you are not entitled to attorney's fees.
In other words, to enforce.
Yes, because we're drawing a distinction between enforcing and defending. And I think that makes
Well,
sense.
now, in this case, though, as Judge Usman mentioned, isn't the defendant trying to enforce the payment of rent?
The defendant is attempting to enforce the payment of rent. The defendant was unsuccessful at the trial court.
If you're wrong about January, February, and March, though, doesn't that change the Section 31 analysis?
If I were wrong about Section 31,
Or about January, February, and March in terms of the rent payment?
yeah. No, because I think you go back to the doctrine of first material breach, which means that, well, you're asking me to assume that my client were wrong on the doctrine of first material breach. So I guess I would have to concede that if my client were wrong on that point, the case would go the other way. But of course, we think
But you don't agree. That's
Yeah.
understandable.
Yeah. If the court doesn't have any further questions, I think I've covered.
All right. Thank you, sir.
Thank you.
All right, we'll hear rebuttal.
Thank you, Your Honors.
Do you want to touch on the attorney's fees distinction between 31 and 26?
Sure. Your Honor, paragraph 31 says, in the event it becomes necessary for lessor to employ an attorney to enforce collection of the rents agreed to be paid, or to enforce compliance with any of the covenants and agreements herein contained, then lessee shall be liable for the attorney fees. As you will recall, my client was successful in enforcing the terms of the lease, successful in having their claims dismissed, and the court ruled that their claims to try to recover the security deposit and the $41,000 were dismissed, and my client prevailed on those.
But that's
And that, absolutely, we were.
That's defending more than enforcing, isn't it?
Well, it doesn't say here defending a lawsuit for someone else trying to enforce. Both parties were trying to enforce the lease provisions. So I respectfully disagree that the state of the law in Tennessee is that the only way you get attorney fees if you're designated the plaintiff enforcing a lease provision. I mean, my client could have sued initially. They preemptively immediately sued to try to recover. My client could have sued and said, not only do we want all the damages and the rent and whatnot, we want a declaratory judgment that they were in default and they're not entitled to the return of the security deposit and the rent, which is basically what we did. I mean, that
did counterclaim, right?
and we filed a counterclaim for all that.
That's like
And
being plaintiff too.
Right, and let's not forget that the trial court here found and ruled that Aureus was the first materially breaching party. So that's what the trial court found and said, hey, you're a tenant, you're failing to pay rent, you're the first materially breaching party. And I want to go back and I want to hit on paragraph 26 one more time because I believe the court is interested in that argument. We believe that argument is somewhat of a red herring because we get back to what was the legal ground for dismissing my client's claim for breach of contract. There's never been one stated, and Aureus cannot even come up with one. They kind of mention a precondition. Are they really arguing it's a condition precedent? Well, that is an affirmative defense. They never alleged that as affirmative defense. They basically never alleged any affirmative defenses. And the trial court found that my client satisfied all the elements of a breach of contract claim, including damages, but then turned around and says, but I'm not going to give you damages because of this failure to follow the lease. I am not aware of any affirmative defense of failure to follow the lease. And there was not any such affirmative defense asserted here. So, and the court even went through and said, there's not a waiver here either. So, there's been a lot of talk about, well, 3803 said it was okay to not pay rent provided you're going to catch it up next week or next month or whatever, which never happened. But the court found there was never a waiver either. But they didn't even assert that as an affirmative defense. So I want to go back to 26 real quick. And it says in the beginning, in the event lessee fails to pay the rent as herein stipulated, or fails to comply with any of the terms and conditions of this lease, then lessor may continue with the lease and recover damages for such failure, or unless lessee corrects and remedies any such failure, which is a failure to pay rent, or default. So you got two different things. We've got a failure to pay rent situation, or we have a default situation that could be for the tenant not complying with any of the other terms and conditions in the lease. And then that paragraph goes on to say there are certain other requirements where it's a non-monetary default versus a failure to pay rent default. And I think there's even a reference that says, except that no notice shall be required with respect to failure to pay rent. So what Aureus would like the trial court to believe and convince the trial court and would like this court to believe is, well, that somehow my client is required to declare a default. And there's nowhere in this lease that ever requires my client to declare a default. So, Your Honors, with that, I see I'm out of time. We would just request that the trial court's dismissal of my client's breach of contract claim be reversed, the case be remanded for a hearing on the damages, and that the trial court's denial of my client's attorney fees likewise be reversed, and we be remanded for a determination of the attorney fees at trial and on appeal.
Thank you both very much for your arguments. We'll take this matter under advisement.